The right to abate exists. The right to abate exists in appropriate cases. When nuisance is caused by an act of commission, I submit, my lady, and I ask you to find that Mr. Thomas was carrying out an affirmative act on the day. So it's not by any omission that the noise was being made. He was actively participating, and we have heard evidence from him that he was in the moment, my lady. My lady, I submit to you that Mr. Luth had a right to abate the nuisance, and she called on the assistance of Mr. Keepsafe. And you have heard testimony that she was afraid of Mr. Fire. He himself, my lady, said that he told her some bad words. She told us in evidence that she hurried away in fear. My lady, necessity is another reason to enter the premises, my lady. Entry upon another person's land may be justified by the defense of necessity, provided that there was no negligence on the part of the defendant. The authority of this, my lady, is Rigby and Chief Constable of Northamptonshire. My lady, we ask that you find that entry of Mr. Keepsafe upon the premises through the agents, that you find an entry of Mr. Keepsafe upon the premises of Mr. Thomas, and necessary one on the morning of January 12, 2008. My lady, we understand quite well that the defense of necessity is available when nuisance is faced by the defendant in an immediate situation. We are submitting that on the morning of the 12th, there was an immediate situation at hand. Mr. Luke said her boy, 7-year-old boy, was sick. I now turn to our substantive defense, my lady, self-defense. My lady, we understand that in civil proceedings, a defendant's belief that he is under attack should be both honestly and reasonably held. And you heard Mr. Keepsafe testimony. And you heard Mr. Thomas. Mr. Thomas said he was in the moment. He didn't like to be disturbed. My lady, we ask that you find that Mr. Thomas was very upset on that morning. We have also heard him say, and I want to quote the exact words, my lady, of Mr. Thomas. No, sorry, it's the evidence of His Princess Diana, my lady, who said that it is our nature to play music at that volume. In cross-examination, she said it is our nature to play music at that volume. We are saying, my lady, that at the old location where they lived, they could have played at any volume. We are suggesting that at this location, my lady, a townhouse, which is part of the Strata Corporation, that this is not allowed. And might I refer you, since I'm here, my lady, it's in your bundle, at the list of legislation, to the Registration of Strata Titles Act, Schedule 1 and 2, which speaks to the implied agreements in the absence of anything else. That people should not be a nuisance to their, in essence what they say, should not be a nuisance to their neighbors, either on their own lot or in the common area. My lady, An essential element of the tort of battery or trespass to person is that the application of force was without lawful excuse, and that the force used in self-defense constituted a lawful excuse. The Court of Appeal removed the reasonableness requirement in the Queen and Williams. I'm sorry, my lady, I did not get a copy of that case. But it was held that the defendant could rely on self-defense if his belief is a necessity, if his belief in its necessity was genuine.
What's the citation for that?
The citation, my lady, is 1984 78 Criminal Appeals Report, page 276, my lady. The court in Ashley and Chief Constable of Sussex, which is in your bundle, has established at page 37 the following: the necessity to take action in response to an attack or imminent attack must be judged on the assumption that the facts were as the defendant believed them to be, whether or not he was mistaken, and if he made a mistake of fact, whether or not it was reasonable, it was a reasonable mistake. It's necessary.
What page is that?
Page 37, my lady.
37 of Ashley?
Of Ashley and Chief Constable, which is in your model.